So hello, welcome to another episode of IANYA Chat. Those who have seen our previous episodes may notice something different about me. We've gotten some comments and feedback on our episodes. They think that I should not be wearing my glasses. As it happens, I can't really see anything. So once we start watching it, the glasses are going back on. But I am curious what you think. Should I try and wear contacts? For me, the idea of sticking little pieces of glass in my eyes every morning doesn't sound appealing, but you know, anything for my art, right? But yeah, leave a comment on whether or not you think the sans glasses look is an improvement, and we'll see. Maybe we will work without glasses in the future. In the meantime, glasses on so that I can see what's happening and we can watch some Shark Tank.
Next into the tank is Scott Jordan, who hopes to entice the sharks with the patent for his clothing technology.
You know, nothing's more enticing than a patent. That's what I always say.
My name is Scott Jordan. I'm the founder and CEO of Tech. I'm seeking a $500,000 investment in exchange for 15% of my company.
Style invest, dude.
You see, I'm a gadget guy. I gotta have my stuff with me wherever I'm going. At any given moment, I've got my cell phone, my digital camera, my tablet, my laptop, and all the gadgets and gizmos and headsets and batteries that go along with it. Technology certainly has made my life easier, but it can be a lot of stuff to carry around, especially when you travel as often as I do. So, what if I told you I had everything on this desk in the vest I'm wearing right now? Introducing Tech, technology-enabled clothing.
Wow. For a frequent flyer who travels a lot of times, the idea of filling my clothes with technology before I go to the TSA checkpoint, like that is some counterintuitive stuff right there. Maybe he likes cavity searches. But when I look at this guy, it's like when I go to the airport, I take off my shoes. I'm like, what am I going to have to do? Are these pants going to fall down when my belts come off? And this guy, instead of going my way, he fills his clothes up with apparently gadgets. You know, that is what separates the true geniuses, though, from just your run-of-the-mill, everyday patent attorney.
Tech is a patented system that lets you carry everything you need, know where it is, and access it easily in specially designed pockets. We've engineered our pockets to fit almost any device, and these pockets are layered into clothing so that there are no bulges and everything is balanced. We've even developed a patented system to wire your headphones right through the lining, so you no longer have to contend with this tangled web of wires every time you have a call or want to listen to your music. I intend to license Tech to every major clothing company because I know that this can become the next huge ingredient brand.
2 days ago, I'm flipping through the back of Men's Journal magazine, and there was a similar product, and I thought, wow, what a great idea. Is that you?
And it is a great idea, and it is my product. I formed a retail company to prove the concept of technology-enabled clothing, and I've been running that company for a number of years, waiting for the patent, and now that it has issued, I'm here seeking an investment in technology-enabled clothing as a licensing company to bring this system, the intellectual property along with the registered brand name and the product know-how to other clothing companies.
Tell me about the retail business, because that proves the concept.
Yes, it does.
What are the sales in the retail business?
Well, to date, it's $5.1 million, and we're on track to do $12 million this year. In terms of the offer I'm presenting here today, it's for the intellectual property and the brand name, the bigger idea, the billion-dollar idea.
We're not going to sell this retail. We're simply going to step back, take the intellectual property, the IP, and license it to others.
That's exactly right.
Burton has done this for years. So what exactly do you have that's different from all the other ones that I know exist?
Well, they infringed on our patent.
Oh, it is about suing people for patent infringement. So this is an interesting deal. So what he's saying is he wants to continue selling this through his retail brand. They're not getting a piece of that. They're getting a piece of the intellectual properties, a percentage of the royalties from the patents, and there's already infringers out there. The interesting question here is about what is damages, basically. So, right, when you sue someone, you are entitled to a minimum of a reasonable royalty or lost profits, compensation for the infringement, essentially. Now, if they buy a share into the patent, they're not going to be able to show the lost profits because they're not actually selling it themselves. They're just enforcing the patent. So it'll be a reasonable royalty. I guess there's questions about, so he's probably licensing it. We don't know what the corporate structure is. Maybe he has a separate patent intellectual property holding company that has licensed this patent out to his retail business. So there'll be questions like, what is a reasonable royalty? How can we tell based on your existing licenses? He says they're already infringing. Has he reached out to them? Have they had negotiations already so far? What are the licenses? What's the sort of standard in the industry? But it's a very interesting question, given that he himself will continue to be manufacturing, of course, under the authority of the patent. This isn't going to be an exclusive license just to the Sharks. And at the same time, they're going to be going after other people, and what they're going to get is a percentage of, it sounds like, the litigation proceeds. Let's see what they say about that. I'm curious where they're going to go with the royalty and what the rates are, if they're going to talk about that.
Have you ever protected it?
Yes.
And you
Could you wait? Yes.
Whoa! All right. Well, so that's an interesting one. They should be asking what happened, right? What was the royalty? What was the payout? I'm also a little curious why he's here. I had thought originally it was to help manufacture the product, right? But then he tells about the retail business, very successful. Doesn't sound like he needs money for that. Then I thought it was going to be money to finance the litigation, because patent litigation is really, really expensive. But if he's already defended it and won, it sounds like he doesn't need that. I'm very curious how this is going to work out, like what their piece is and why he needs it from them. Let's see what we have.
I settled with 11 of the largest companies, including VF Corporation, North Face, Ralph Lauren, Calvin Klein, Under Armour, Spider.
You getting an ongoing royalty?
It's subject to confidentiality agreement.
Wait a second, though. Is it getting a royalty stream from the settlements? You don't have to tell me how much.
Yes.
Okay, listen.
And is that part of your bottom line?
Stop right now. You need me very badly. I know how to sue.
Now this is interesting. I'm just curious why it makes sense to go through a lawsuit with the 11th of 12 big infringers. How much their market share is, right? How much royalties they're expected to pay. Why didn't already sue them?
I want it all, though. Why are you just giving me a taste? The problem is there's leakage in the deal.
What exactly is the property that you own that you can defend and have defended?
A garment with no wires in it, but the capacity to wire things in it.
Is it a design patent?
Yeah, design and utility
It's been
patent.
issued.
Not only issued, not only tested in litigation, but recently re-examined and passed re-examination.
So basically,
No, re-examination, so it sounds like he's got some solid sounding IP. What re-examination is when you get a patent, it's presumed to be valid. It's examined by a patent examiner. They compare it to the prior art. They make sure that it satisfies various requirements about form. But let's say you've gotten the patent and someone comes up and they say, well, wait a minute, here's another patent that someone else got before you that we think is so close you shouldn't have gotten a patent. Really, you weren't the first inventor. Or maybe you invented something, but it's so small that you shouldn't have gotten a patent because it's obvious relative to this other one. You can give that to the patent office and say, patent office, I would like you to re-examine my patent in light of this thing, whatever this patent or description, some white paper, something. And then they will, and they can issue a re-examination certificate basically saying, we've looked at this and you're good to go. So it sounds like he's been through litigation. Of course, in a lawsuit, they're going to attack your patent. He's been through re-examination, so that's an attack against the patent. He's gone through all of it. I don't know his intellectual property, but it sounds quite well vetted. My bigger concerns are a lot of what Kevin was talking about, the sort of leakage, right? Because there's this other, he's not the one who's going to be exclusively exploiting this patent, right? Kevin isn't doing that. There's this manufacturing company. That's kind of the bigger concern, is how much damages are really out there with it.
patent is attributable to the wires.
That's right.
Only the
So
wires.
that, for example, this pocket here has a hole in it that leads up through here.
That's ridiculous. That is ridiculous. That's just common sense. Wires in, wires out. That's what's killing this country, that we get dumbass patents that people then turn around and sue. Mark Cuban. Okay, so this is a pet peeve of mine, right? I'm a patent attorney.
People say, oh, that's so obvious. You should never have gotten a patent for that. All right, this guy, his retail business, what did he say? Something like $5 million? If it's so freaking obvious, why didn't you go and you do that back in the day? Well, maybe you, not you, Mark Cuban. Why didn't some other person do it? Because you're a billionaire, you don't care about $5 million business. But there's a lot of people who like $5 million. And if this is so obvious, why didn't one of them do it? I'll tell you the reason why they didn't do it. Because this is only obvious with the benefit of hindsight. This person came up with something that no one else had. His patent has been through litigation, it's been attacked multiple times. It's a successful business, and now you're saying, oh, this is what's wrong with this country. No. This has been put through the ringer by people who have spent a lot of money. I would bet the people he sued, who says 11 of the top 12 garment makers, they have collectively, probably individually, spent millions of dollars trying to kill this patent. And a way you can kill a patent is if you can convince a judge or a jury that it would have been obvious at the time you made it. Not with hindsight. The law is very clear. It's not hindsight. It's at the time you made it based on what was available then. And if this is so obvious, why would they have spent, and again, I'm pretty sure this was millions of dollars, why would they have spent the millions of dollars to do that and then said, oh, you know what, we're just going to pay him a royalty now. If you were right, if you were not just talking out of some part of your self that isn't usually used in thinking, you would realize it can't be that, because they would have gone to trial and they would have ended up paying him nothing. This just bothers me because it's so easy to say something is obvious. Oh, anyone could have done that. You know what? People didn't do that. This is an established $1 million idea, and if the problem with this country is that people can get patents with $1 million ideas, then this country's doing great, because honestly, that is a problem low on my list of problems. That's a great problem to have. All right, I'm done ranting. And let's go on. Mark, I can't believe this guy's a technologist. I'm not going to comment anymore on Mark Cuban's patent thing. I'm lying. I'm totally going to, but I'm going to stop for now.
Running a wire through a piece of clothing?
I'm telling you, Mark.
That's a patent? Are you kidding me? What? Who cares? What is it? No. You're so full of crap.
Scott, the cases you have defended have been when, argument's sake, let's say one of my designers, and I have 30 of them, decide to wire something, a hood or something else like that. It goes out. We don't even know you exist and have that patent. You hit us. We say, instead of paying the attorney bills, give them 50 to go away because we don't have time for this. And that's it. And that's the reason why you got to defend all those patents.
Horrible. I didn't say that.
Man, I want to know what those settlements were, which we don't. But here's the thing about what Damon was just saying, right? Is you pay this nuisance settlement. And there is such a thing because patent infringement litigation is expensive, as I mentioned before. But the way he's described it, it's a patent for putting a wire through a piece of clothing. Okay. No, it's not. So patents, they have claims at the end of them. The claims are descriptions of what you have invented, and they have the various components of that. So it might say, I have a piece of clothing. The clothing has an inseam. It has such and such wire through the inseam. It connects to this in this way. But essentially, it's a description of the subject matter that you believe to have invented, and it's going to be more than just a wire through a piece of clothing. Now, when he's describing it here to them or to an investor, you don't go through the whole patent claim. It maybe is going to be 100 words or 50 words or 200 words or something. You're not going to go through that whole thing to an investor, but the patent itself is going to be more precise than that. The other thing I wanted to say on this, though, is when you're in litigation, one of the questions in terms of damages is, what are my substantial non-infringing alternatives? So if I come and I sue you and you say, oh, well, I didn't know, so I'm just gonna, I guess I'll do it in a different way or I'll pay a different thing, the damages that you can get out of that lawsuit are gonna be lower if you have a non-infringing alternative that does the same thing. It's easy to denigrate and it's easy to attack things, especially when he can't really defend himself because the settlements are confidential. But in practice, it's like saying something is obvious. It's easy to do when you don't have all the information, but it could be that he's got a lot more than these people are giving him credit for, and I can't believe I'm agreeing with Kevin. And maybe they're talking it down because they're going to make an offer and they want to say, oh, your thing is worthless, I'll make an offer, I'm going to lowball you. But it is surprising to me that this group of people who are in licensing, who are in technology, are really seeming very adverse, again, except for Kevin, to what this person has and what this person is trying to offer.
Scott, just to be really clear, you don't want to sell us any of that business. You just want to take the idea and sell us the patent.
Yes, I do. My other business only has a very insignificant part of a much larger market.
No, because your other business could end up being the billion-dollar business that we have nothing in. You're going to grow that business.
Yeah, see, that's the concern, or a concern, right, is the license can't be an exclusive license to the Shark Tank people. Or if they own the patents, they would have to grant some license to his existing business. And then once all these competitors are run out of the market, which it sounds like 11 of them are, that's going to make his existing business just great. Now, there should be a royalty stream to the Sharks from this. So let's say that there's a patent that's been put into an LLC and he's licensed the patent to his existing business. If there's a royalty stream attached to that, then the existing business should have more sales, so the Sharks can have more royalties. But we don't know what the terms of that are, or how much of that is going to come in. What if it was a lump sum payment where they say, we're going to pay $50,000 for the right to use this patent to the... Then it doesn't matter if their business goes through the roof. Or let's say it was low, or there's a high amount for the first 50,000 units and then a low amount later on. So there's all these questions. That's something that I would be very interested in, because that's, again, they're not getting a piece of that, and it can't be exclusively for them because he's planning on keeping this business going. So the real question is, as he keeps this business going, how much of the money from that is going to flow back to them through this patent?
Would you sell me 15% of that business for $500,000? You've got to be kidding.
That's insane.
You just called him insane for offering you $500,000.
For a company that's making $2 million
So why are you here?
That is a question. Why is he here?
I think it's an insult that you wouldn't offer us part of the bigger picture. I'm out.
You know, Scott, the way it works in the tank is we make our offer, then you counter. Kevin, you're out. You're out.
Whoa!
I don't need you. Wow. What the hell? You point at me and you tell me I'm out? Bye-bye. Show a little more respect.
Wow. That was amazing. I haven't seen an entrepreneur tell the Sharks they're out. That was interesting. The thing that blows me away the most is Mark's attitude towards the patents. Because he is savvy. I would expect him to know that it's not a patent on a wire in clothes. Like, he should know, and I'm sure does know, that when you're pitching, you describe something, it's at a high level, there's a patent, it's going to have much more information, much more detail. His patents have been through several ringers in terms of the original examination, which they had to be approved by an examiner who served through the prior art, in terms of the litigation, where you got some kind of settlements. Again, we don't know what it is. Maybe it's just a nuisance. On the other hand, nuisance is usually they will pay you just like, here's a flat amount of money, which is based on what we think our litigation costs are going to be. We're done. It's not going to be an ongoing royalty because, but if you sell a whole lot of them, then it's going to be more than your litigation costs. So, maybe it was a nuisance settlement, maybe not. Sounds a little bit more than I would have just expected for a nuisance settlement, but I don't know. They went through the re-examination, and for him to say, oh, it's just a patent on wires through clothes, this is destroying the world, this is junk patents, I'm just very surprised that a person who I would expect to be savvy took that approach and made those kinds of statements, because it's just wrong. And that's all I have to say. It's wrong, and just like Mark said, it's un-American, right? He says patents are un-American. This is the problem with this country's Forget that. This is the problem with when people talk about the patent system, is they think, oh, I am so smart, I'm going to Monday morning quarterback, I'm going to hindsight this. They don't see the actual patent, they don't do the actual analysis, and they think they're smarter than the original examiner, the people on the re-examination, and everyone who's involved in that litigation who decided this was worth an ongoing royalty. Well, Mark, you're a very smart man, but you're just wrong on this one. So that wraps up this episode. If you like it, let me know. It was a little bit more ranty than I usually am, but people who ding the patent system, they just get on my nerves and under my skin. If you don't like it, let me know that too. I'll try and be a little bit more reserved. In either case, like, share, and subscribe so that I will know people are actually watching this, and so that more people will watch in the future. Thanks a lot.